and welcome back to our series where we're exploring the changing US state privacy landscape. In our previous episodes, we examined the latest US privacy laws in Texas, Florida, Oregon, and Montana. Now, in recent years, January 1st has become a significant date for the implementation of US privacy laws, and this year was no exception. At the start of 2025, 4 new state privacy laws took effect in the form of Delaware's Personal Data Privacy Act, Iowa's Consumer Data Protection Act, Nebraska's Data Privacy Act, and New Hampshire's Consumer Data Protection Act. These laws follow familiar patterns set by privacy legislation, but they do include some nuances organisations may need to address. For instance, all 4 laws outline the types of sensitive personal information we've come to expect with modern privacy laws. They cover things like racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sex life or sexual orientation, citizenship or immigration status, children's data, and precise geolocation. Delaware, however, expands this definition to include individual status as transgender or non-binary. Notably, all 4 laws require opt-in consent for processing sensitive personal information. Consumer rights remain a cornerstone of US privacy laws and typically include a core set of rights. This trend continues with 3 of the 4 laws allowing consumers in Delaware, Nebraska, and New Hampshire to have greater control over their personal information through the right to confirm processing, the right to access, the right to correction, the right to deletion, the right to data portability, and the right to opt out of targeted advertising, sale of personal information, as well as profiling. Delaware goes a step further, granting consumers the right to obtain a list of third parties with whom personal information was shared. And organisations covered by these laws will have 45 days to respond to requests. Iowa, in contrast, provides a narrower set of rights limited to the right to confirm processing, the right to access, the right to deletion, the right to data portability, and the right to opt out of sale of personal information. But note that this law does not address the targeted advertising or profiling specifically when it comes to individuals' rights. Organisations in Iowa have up to 90 days to respond to requests, so have a little bit more flexibility there as well with this law. When it comes to risk assessments, Iowa stands out again by not requiring a formal risk assessment. Delaware, Nebraska, and New Hampshire each require risk assessments for activities such as targeted advertising, the sale of personal data, profiling, and processing sensitive data, among other things. Enforcement is where the most difference between these 4 laws becomes apparent. So when looking at penalties, Delaware and New Hampshire present monetary penalties ranging up to $10,000 per violation, whereas Nebraska and Iowa range up to $7,500 per violation. Typically, these laws will be enforced by the relevant state attorney general, apart from in Delaware, where the act will fall under the purview of the Department of Justice. Cure periods range from 30 days in Iowa, 60 in Delaware, and 90 days in Nebraska, with none of the 4 laws offering a private right of action. Now, compliance with the requirements of 4 new privacy laws might seem like a steep mountain to climb, but fortunately, many organisations will already have requirements in place that allow for this, since the familiar pattern we've seen across the states fit with the framework you probably have already. But check back soon for our next instalment of the US privacy video series, where we'll be looking at New Jersey's Data Privacy Act, which took effect just 2 weeks after this group of laws.